Good morning, ladies and gentlemen. Welcome to the Max Planck Institute for Procedural Law. We are on the eve of a 3-day conference, and it's the 50th anniversary of the Brussels regime. And I'm very happy that we are starting this morning by looking forward into the future of the system, the challenges ahead, and tomorrow and the day after tomorrow we will maybe rather look a little bit back at the system, how it has developed during the last 50 years. And just to start by one slide, what you can see here is a situation 50 years ago. We have the 6 member states of the European Community, the foreign ministers meeting at Brussels and signing the so-called Brussels Convention. Where are we standing today? What are the challenges? What are the achievements? There is no doubt that the Brussels regime is a success story. Much critique has been made concerning the case law of the court, some solutions adopted by the lawmaker, but all in all we can say that the free movement of judgments within the European Union is assured, is working, and it's working quite smoothly. Just imagine where we were standing 50 years ago, where cross-border litigation was a rare exception. I would not say that today we are in a situation where those cases are an everyday business of the courts in the Union, but it's possible to enforce claims in a cross-border setting, and access to justice for litigants as a matter of principle is assured, and fundamental rights, especially Article 47 of the Charter, guarantee fair proceedings throughout the Union. Of course, there are member states where litigation is more smoothly than in others, but nevertheless, all in all, I would say the system is in a balance. So we are going to celebrate this anniversary during the next days, and the idea was to start with a so-called pre-conference, a pre-conference with younger researchers presenting papers on the most challenging issues surrounding the Brussels regime. And we will start this morning by a very classical approach. We are going to look at the jurisdiction issues like actor, sequitur, forum, re, proximity, and then we will move forward to topics like collective redress, how to enlarge the system. We will look at challenges surrounding IT and the information technology revolution in the courts. And we will finally end up by asking, where are we standing now? What about the crisis of the Union and the challenges for the Brussels regime? So I'm very confident that we will have a very open and interesting debate here in the room. The basic idea behind this conference is as follows. We will have speakers, papers presented, and then we will have an open debate. And my idea is that we will have this debate not going forward and backward from the podium to the audience, but that also in the audience we will discuss it in a very open academic setting. So I'm very grateful for all those who have submitted papers for the speakers, to the speakers of today. And I would like to invite the first panel just to start. Thank you.
Bonjour à toutes et à tous. It's my pleasure to introduce our two first speakers this morning. First, Etienne Farnoux, who is maître de conférence at Sorbonne University, Paris 1, where he completed his PhD, defending his dissertation on, I say in French, les considérations substantielles dans le règlement de la compétence internationale des juridictions, réflexion autour de la matière délictuelle. There is at least a close link, even a connection with this speech today towards the jurisdictional protection of the alleged victim in cross-border torts. And talking about close link, about connection, Lucilla Galanti will then speak about the Forum connexitatis and how to improve the close connection criteria. Lucilla teaches civil procedure at the University of Bologna, where she completed her PhD, defending her dissertation on arbitration and insolvency proceedings. So I guess that we will learn a lot about proximité, connexité, and maybe the need of a substantive approach to international jurisdiction, far beyond the actor sequitur forum ray. There will be a time at the end of the two presentations for any question or comments you may have. And I think we have a coffee break after the session, and I thank you for 20, 25 minutes, and then we will have plenty of time for the debate. Now, Etienne, the floor is yours.
Thank you. Thank you, Professor Menétrey. And thank you for the Max Planck Institute for inviting me for presenting this paper. As Professor Menétrey mentioned, this paper gathers a few of the conclusions that I've reached in my PhD dissertation. Of course, the title of the paper, Delendum est Forum Delicti, is a reference to an article published by Georges Droz in a French law journal. I will come back to that later. The title of the presentation is Towards the Jurisdictional Protection of the Alleged Victim in Cross-Border Torts. As an introduction, I would just like to briefly underline that, as we all know, there are two fundamental principles of the European rules of international jurisdiction in the Brussels system. The first principle is that jurisdiction is generally based on the defendant's domicile, what we know as the forum rei. We see that in Article 4 of the Brussels Regulation recast, in Recital 15, from which the quotation is taken. And there is a fairness justification to that rule, to that principle, the actor sequitur forum rei principle, which is that since at the jurisdictional stage the defendant does not owe anything to the claimant, it's only fair that the claimant has to sue the defendant at her home court. This I call the principle of jurisdictional protection of the defendant. The second principle is that there are alternative grounds of jurisdiction based on a close connection between the court and the action. We see that from Recital 16 of the Brussels I recast regulation. And of course, Article 7.2 of the same regulation allows in matters relating to tort, delict, and quasi-delict for the jurisdiction of the courts for the place where the harmful event occurred or may occur, what we call the forum delicti. The general idea behind the forum delicti is that the geographical localization of the elements of the dispute should determine the jurisdiction of a given domestic court. There are many reasons for that. I think the main reason that I should emphasize today is a question of predictability. and of sound administration of justice, especially, of course, concerning evidentiary issues. The court that has the closest connection with the material elements of the case will be best placed to gather the evidence. So the case law, both in domestic courts and at the European Court of Justice level, under Article 7.2 of the Brussels system, usually deals with issues concerning the localization of the material elements of the dispute. Where is the harmful event? Where is the locus delicti? And as we know, sometimes this operation is doubled, and we try to find where is the event causing the loss, the locus delicti commissi, and where is the loss itself, the locus damni. However, both principles are faced nowadays with dire difficulties. The first difficulty, of course, is that the localization program, proximity, as we call it, the proximity principles, becomes less relevant. That has several justifications. There are several reasons for that. Maybe the main one would be the growing virtualization of human activities. The second difficulty is that very often we find that the forum delicti allows the plaintiff to sue at home and not at the defendant's home. So there is a de facto forum actoris that happens. To the point that I'm asking myself whether the principle of actor sequitur forum rei still holds. And there are two possible answers for that. The first one is yes, and the principle still holds. The de facto forum actoris is only a coincidental result of the localization operation. But a second answer could be that no, the forum delicti actually plays an undercover role of jurisdictional protection of the alleged victim, and that outside of the scope of the provisions that traditionally offer a protection to the claimant, and I'm here thinking of sections 3, 4, and 5 of the Brussels I recast regulation. So the question that I'm asking is whether there is a possibility and a need to transform the current forum delicti into a forum actoris of the victim, what I call a forum victimae. So this is where I join this question that Georges Droz asked 20 years ago. Delendum est forum contractus, he asked in 1997. And so my question would be, delendum est forum delicti. Should we get rid of forum delicti? But actually, my question would be rather, should we transform forum delicti into a forum actoris of the victim, a forum victimae? And this I study in the case law on cross-border torts. So my outline is as shown on the screen. The first part will be on the rise of fora actorum in tort litigations, and the second part on the replacement of the forum delicti by a forum victimae. So first, the rise of fora actorum in tort litigations. What exactly is the magnitude of this phenomenon, and what are its causes or justifications? So first an overview, then an explanation. As for the overview, so contrary to the principle of narrow interpretation of alternative connecting factors, a principle that is closely linked with the principle of jurisdictional protection of the defendant, there are ways through which we find that a forum actoris happens. And I listed 4 that I will come back to. Forum actoris through forum delicti, forum actoris through derived jurisdiction, the question of the low standard of proof at the jurisdictional stage, and a specific example regarding data protection. So as for the first channel through which forum actoris happens under the Brussels regulation, it's forum delicti. The first step in this path towards forum actors, I think, can be found with the Birmin-de-Potas case, very well known, of course, and the principle of ubiquity between the place of the event causing the loss and the loss. This, in some cases, leads to forum actors because the location of the loss will very often be within the victim's home state. And one example of this is Colassa, a case of financial loss. Of course, in the case of what the court calls the plurilocalized loss, there is the mosaic principle that amounts to a functional limitation of the jurisdiction of the court based on the local loss, except that in many cases, the local loss is actually predominant. So this functional limitation is actually not very successful in reining in the possibilities of the claimant to sue at home for at least a large part of the total loss. Of course, the question that is legitimate is whether it is only accidental that the forum delicti turns into a forum actoris in the hands of the victim. And in the abstract, of course, it is only accidental because it's a forum delicti, it's not a forum actoris. But statistically, I find that in many cases, it actually turns into a forum actoris in the cases. And the reason for that is that in most tort cases, the claimant will try and sue at home. So the claimant will only use forum delicti if it allows him or her to sue at home. And the relevant question is not whether forum delicti allows the alleged victim to sue somewhere else than at home, but whether it allows him or her to sue at their own domicile. One last point is that finally and strikingly, in the Edate and Martinez case, the Court of Justice opened an explicit forum actoris of the victim for infringement of personality rights on the internet. And there's always this question of wondering whether this is an exception to the localization approach or whether it's just a new way of localizing the loss. And I think that's something that we see in the recent Bollag-Supply-Sningen case. Also, one point that is interesting is that the place where the loss occurs may be used against several defendants. So that allows the plaintiff to sue at home against several defendants. And an example of that would be in the Pinckney case. The second channel through which forum actoris may happen, and I will go maybe more swiftly on this one, is derived jurisdiction. It allows, in some cases, the claimant to sue at home out of forum defendant. Of course, there are preconditions, but I think one striking trait is that those preconditions have been loosened. They're pretty loose, and they, in many cases, allow the claimant to sue at home. One other channel through which forum actoris happens is the low standard of proof required to establish the facts relevant at the jurisdictional stage. Of course, the jurisdictional stage is preliminary, so the amount, the threshold that the claimant has to reach in order to create the jurisdiction of the court, to claim the jurisdiction of the court, will be pretty low, and that can be seen in the Colassa case. One last example of forum actoris that I find very interesting is a specific one, a specific explicit forum actoris in the realm of data protection, in the data protection regulation. Article 79, paragraph 2 allows for a forum actoris in a field that's really close to tort litigation. So, as a conclusion for this first part, Of course, forum rei remains the principle within the European jurisdictional system, there's no question, but in many instances, the alleged victim will be allowed to litigate at home for the whole or part of the alleged damage. Is this a coincidence, or is this the result of some deeper tendency within the jurisdictional system? And this leads me to formulate an explanation. There are two opposite ways to look at the rise of forum actors. One is traditional, and it basically says that it's only the result of localization. And the other one would be that there's actually a tendency to favor the plaintiff. There's a tendency of favoring the plaintiff. If I deal with the first explanation, localization, of course, when we look at the case law all the way back to Mine de Potasse and Fiona-Cheville, and up to today, it's the localization that explains it all. It explains the doubling of the claimant's options, it explains the limitation of the jurisdiction, it explains the way the loss and the event causing the loss are located. However, we have to admit, I think it's undeniable that localization is not very convincing in many cases. It's not convincing in the case of financial loss, it's not convincing in cyber torts, it's usually not convincing for infringements of personality rights, be it on the internet or in the real world, and it's not very convincing for intellectual property rights. The example that I think of is that there have been questions. There have been questions and proposals to get rid of the Fiona-Cheville localization process after the E-Date case and during the discussions about the Bolai-Supply-Sningen case. Both cases that deal with infringements of personality rights on the internet. And there have been proposals to get rid of the Fiona-Cheville mosaic approach and to offer a simple option for the claimant between his or her domicile and the domicile of the defendant. And this, I think, underlines the question, the fact rather, that the international jurisdiction is framed, or should be framed, as an opposition between the forum rei and the forum actoris, and not as a localization question. But if that's the case, if actually the question of international jurisdiction is a question between forum rei and forum actoris, the choice between them two, well, the actor sequitur principle provides an easy answer. The principle should be the jurisdiction of the court of the domicile of the defendant. Why is it not the case then? Why do we constantly allow the claimant to litigate somewhere else than at the defendant's domicile? And I think the explanation is that there's a tendency within the Brussels system to favor the plaintiff. There's a tendency of favoring the plaintiff. To the point that I wonder if the principle of jurisdictional protection of the defendant has been overturned. There have always been questions whether the forum delicti was actually from the start granted as a favor for the alleged victim. And it's something that was talked about after Mine de Potasse, after the beer case. Of course, we know that the Court of Justice is reluctant to admit this. We see that in the Folien-Fischer case, where the court ruled that an action for a negative declaration is not excluded from the scope of forum delicti, because the court said forum delicti is not concerned with the protection of the victim. One question that I have is whether this result is not unfortunate, because in many cases this allows the alleged tortfeasor to be able to benefit from the options that were originally open for the claimant, for the plaintiff. And again, in Beleihsübleisningen, in order to allow legal persons to benefit from the forum actors, I mean the jurisdiction at the center of the victim's interests, the court ruled that forum delicti is not concerned with the protection of the victim. And I wonder, is it really so? When I think back of the E-date case, it was pretty clear that there was a dimension of protection of the victim. If there is indeed a movement of favoring the plaintiff, it would be legitimate to ask why. Why overturn this really stable and well-accepted principle of actor sequitur forum? And I move to my second part, which will be faster, which deals with the replacement of the forum delicti by a forum victimae. If the Brussels system actually favors the plaintiff in tort litigation, then why not go ahead and create a forum actoris of the victim, a forum victimae? First, I will deal with the reasons that I find to replace the forum delicti by a forum victimae, then I will briefly outline a regime. What are the reasons to replace the forum delicti by a forum victimae? What are the reasons for favoring the alleged victim? The hypothetical that I have is that there is a substantive tendency, or there are substantive tendencies within tort liability that favor the victims, and these tendencies, they stem from the two functions of tort liability: the reparation compensation function and the normative regulatory function. The reparation compensation function of tort law influences the jurisdictional rule to favor the plaintiff and allow him or her to recover its loss. That's the reparation aspect of tort litigation. On the other hand, the normative regulatory function of tort law emphasizes that the claim for damages by the plaintiff is in the general interest of the community because it acts as a deterrent for harmful conducts. So there's a private utility individualism aspect of it, the reparatory function, and there's a more greater good function. But both these functions of tort law could provide incentives for the legislator and the courts for overturning the principle of jurisdictional protection of the defendant in favor of the plaintiff. And there are also valid reasons to get rid of the forum delicti. Some might argue that the result of the localization process is not foreseeable, and we see that if we trace the case law from Marinari, Chronofer to the Colassa case, Löber case, and Universal Music case for financial loss, for instance. Also, forum delicti is definitely more forum shopping friendly than a forum actoris. And it's open, according to the case law, for negative actions for a negative declaration of liability, which is also something that allows more forum shopping. Of course, we have to admit that it's for the legislator and not for the court to replace the forum delicti by a forum victimae, and because there's a policy aspect to it, but also because there are thorny issues ahead. And I would refer here to the opinion by Advocate General Bobek in Beleihsübleisningen case. Some of the questions that were asked in this opinion about the forum actoris of the alleged victim of infringement of personality rights on the internet are: should natural person be included? Should these forum actoris be available against all defendants or only strong defendants? And what's a strong defendant? So this brings me to my last point, which is the regime of a forum victimae. One thing that I think we can agree on is that a forum victimae should be only open to the victim. There should be no actions for a negative declaration of liability. That's something that we can discuss later. The next question is, should the forum victimae be the only forum available to the victim? I think the point is to get rid of the forum delicti, so it should be, forum delicti should be deleted. What about forum rei? Should the claimant, the alleged victim, be allowed to choose between forum rei and forum actoris, forum victimae? Of course, the advantage of such a solution would be that there are reasons to believe that forum rei is a legitimate base of jurisdiction, but this increases the risk of forum shopping because we know that the claimant will only use the forum rei if he or she finds it useful for purposes that are not in favor of the defendant. Next question would be, should it be a general forum victimae or a forum victimae only for the weaker party? There are pros and cons to each possibility. A general forum victimae would have the advantage of getting rid of forum delicti as a whole, but it's open to a risk of abuse. So maybe there should be a procedural control to the type that exists under English law for service out of the jurisdiction, a sort of preliminary jurisdictional stage at which the claimant should show that the claim has a probability of success. If we go for a forum victimae for the weaker party only, the advantage would be to not completely overturn the forum rei principle. There would be room for jurisdictional protection of the defendant. And we could do that by replicating the protection of the consumer, but without a contract, because this is a tort litigation. So this forum victimae of the weaker party would be available when the loss occurs outside the profession of the victim and the alleged tortfeasor is a professional. What are the drawbacks? Well, it leaves out professionals and small businesses that might legitimately have a claim for protection. The last question is whether this forum victimae should be open only for individual actions or also available for class actions. Well, one element of answer would be that if the reason to open a forum victimae in the first place is the protection of the weaker party, then maybe there's no need for an extra protection when the weaker parties are made stronger by the collective action. As a conclusion, I think it's undeniable that the rise in fora actorum seems hard to resist in cross-border litigation. Of course, there are exceptions, universal music, Löber, to name a few. I think this rise is explained by the incentive at the substantive level to favor the plaintiff. And at the same time, there are reasons to delete the forum delicti. So now that the true functions of a forum delicti is revealed, this protection of the alleged victim function, maybe it's time that we get rid of forum delicti and replace it by a forum victimae. My idea would be that this forum victimae should be limited to the weaker party, because that would still allow for the protection of the defendant, and I think there are still, it's still a mainstream view that the principle of protection, of jurisdictional protection of the defendant still holds true. It still has some value. Thank you.
Thank you very much, Etienne, for this very inspiring presentation. With Forum Victimae, we are for sure far beyond the actor sequitur forum rei. I'm sure that you have already thousands of questions and comments, but we will maybe move to the next presentation and then discuss together. Thank you very much, Etienne, again.
First of all, I would like to thank you for inviting me in this conference. I'm very glad to be here. It's for me a great honor to be here. My presentation concerns the forum connexitatis under Article 8, Paragraph 1. In particular, that disposition provides for a rule of special jurisdiction which applies to multi-party proceedings. And in particular, it allows the claimant to sue the defendants before the court of the state of one of the defendants, thus derogating the domicile of the others. And this is possible when the claims are so closely connected that there would be a risk of irreconcilable judgment. This provision has some problems of application. There is a great problem in defining the scope of the rule. And in fact, the article does not define the close connection. Its content is void in itself. In the wording of the article, the connection is strictly related to the irreconcilability between judgment. But this irreconcilability does not define in itself the scope of the rule. And an analysis only focused on this topic, so on the irreconcilability, could not lead to a clear definition of the scope of the rule and of the close connection. And in fact, it seems that the irreconcilability is instead a part of a broader examination. And as it emerges from case law, irreconcilability is strictly linked to another element, which is the existence of a same situation of fact and law. In the case law, in fact, there is another exigence of individuating the irreconcilability because it is not only necessary the existence of a divergence in the outcome of a dispute, but it is also necessary that the disputes lie on a same fact and law. So the irreconcilability must arise in the context of a same situation of fact and law. And this is this requirement which becomes the core issue in defining the scope of the rule. And in fact, the interpretation of this requirement has sensibly changed in the case law of the Court of Justice. At first, Court of Justice adopted a very strict approach in defining the existence of a same situation of fact and law. This would mean that for a same situation of law to exist, there would not possible to find different legal bases, and thus in presence of different legal bases, the rule was not applicable. And this approach emerged from two judgments in particular, which are Union Européenne as well as Roche-Nederland. In Union Européenne, the court excluded the application of the rule because in these claims, some of them were based on contractual liability, instead others were based on tort or delict. And thus, for the court, a difference in the legal basis would not suffice to individuating a same situation of law. Also in Roche-Nederland emerged a same approach. In that case, the claims were related to an infringement of an European patent. And since the patent is regulated by the different national laws, for the court there would not be a divergence which could emerge in the same context of law. In this claim, the court also approached the existence of a same situation of fact and excluded it because there were a plurality of defendants which have acted in different territories and in different ways, and thus the infringement they were accused of were not the same. it must be underlined that in this case, the defendants were companies belonging to a same group, which have also acted in accordance with a common policy. But for the court, the conclusion does not change. In fact, even assuming that in this context there will be a same situation of fact, there was not a same situation of law. And to that conclusion has a relevance the role of predictability. Predictability in the consolidation between the claims. Since Article 8, Paragraph 1 is a rule of special jurisdiction, it is expedient that the defendants are able to understand that they may be sued together in the forum of one of them, so in a forum different from their own domicile forum. And thus, for the Court of Justice, the existence of a different law determines the impossibility of foreseeing the difference of the forum. And a rule of jurisdiction only based on factual criteria would be able to undermine the predictability of the Brussels system. This approach would lead to undesirable conclusions, since there would be not a determination of claims which could be really connected in a separate way. And in fact, at a later stage, the court has adopted a less formalistic approach. And in particular, this emerged from two judgments in Freeport and in Painter. And in this context, what concerns the court is the identification of a substantial identity of fact and law. This would mean that for a same law to exist, it would suffice the existence of a legal framework even not fully harmonized, where the essential elements of the law are the same. And this is stated in Freeport, where the court excluded that the difference of the legal basis would lead to the disapplication of the rule. The same is stated also in Painter, where in particular the claims were related to some copyright infringement, and in which the court stated that the existence of different legal grounds would not lead to the disapplication of the rule. This because the essential elements of the different law were substantially the same. A similar trend characterized also the appraisement of the fact, since in this case there were different defendants which have acted in different ways, but the court underlines the fact that the action were or not independent. And thus, what emerged is the relevance of concerted actions. This element of concertation has some consequences also on the notion of predictability. And in fact, the more extensive approach in evaluating the same situation of fact and law has a real consequence in the evaluation of the notion of predictability. From the previous perspective, in which predictability was strictly related to the existence of a same situation of law, when the identical legal basis is no longer necessary, the same situation of fact becomes more relevant. And in this perspective, the predictability is itself related to the existence of concerted actions. In this perspective, the defendants may be considered able to reasonably foresee that they can be sued in a different forum if they have concerted their actions. The comparison between the judgment in Painter and in Roche Netherlands reveals that the broader evaluation of the notion of the same fact and law is particularly relevant to this case in which could be existent an infringement of intellectual property rights, since in these cases are naturally involved a plurality of parties and infringement, and thus there could be a consolidation of the claims if substantially considered. And in fact, this more extensive approach has been confirmed in Solvay, a case related to patent infringement, and thus the same very field in which Roche Netherlands took the opposite strict approach, and in which the court recognized the existence of a same situation of fact and law. And the same broader evaluation in the situation of fact also emerged from Nintendo, where the judgment in particular considered the appraisement of the fact, and in which the court recognized the existence of a same situation of fact since the defendants were a subsidiary and a parent company, and they have acted in a similar manner in accordance with a common policy. The application of the rule can be appreciated also in the field of competition law, where in particular it has been considered in the cartel damage claims case. This judgment is of particular significance since in that case there was a decision of the Commission which, before the introduction of the proceedings, already established the existence of a unitary infringement and found that several undertakings had participated to a same cartel. And thus, even if in the claims the defendants have acted in different manners and in different territories, this element, the decision of the Commission finding a same infringement, is relevant to individuate the same situation of fact. The decision of the Commission did not establish also the legal basis, so the applicable law, because the requirement to find the liability of the participant in the cartel had to be determined by the national laws. But for the court, this does not lead to the disapplication of the rule. And the reasoning of the court goes even further, since because the requirements of the liability would differ between the various national laws, this could lead for the court to a possible irreconcilability. And from the previous perspective, in which a difference in the legal basis would lead to the disapplication of the rule, under this approach, it's possible that a divergence in the law determine the application of the rule. This could lead to some interim conclusion regarding the element of close connection, which emerges like an objective requirement of the scope of the rule, which exists when there is a substantial same situation of fact and law under the comprehensive approach adopted by the court, which can exist also where there are a plurality of misconducts if concerted, and a concertation may also emerge where the defendants are different companies belonging to a same group. For what concerns instead the same situation of law, a same legal basis could also exist where the legal framework is not fully harmonized, but the essential elements of the law applicable are substantially the same. But what's more, there are some cases in which the law applicable is not a necessary element for finding a close connection. And so there are cases in which the connection hardly depends on the law, but on the fact. And in this perspective, the same situation of fact and law could be excluded in presence of a lack of predictability. But also the predictability changes its features, since from an original approach in which predictability was strictly related to the same situation of law, it seems that it becomes an element related to the concertation of the actions. The analysis of the rule would not be completed without considering a last element, which is the relevance of other subjective conditions for its application. since Article 8, paragraph 1 does not require a subjective condition. And this is different from Article 8, paragraph 2, where instead the consolidation of the claims is not possible when the claims are brought with the sole scope of removing the other defendants from their natural forum. In Article 8, paragraph 1, this requirement is not included, but notwithstanding, already in the Generd report, it stated that the claims cannot be brought with the sole scope of hosting the general rule of jurisdiction. And this principle is held also in case law. Even if the relevance of this principle is stated at principle level in case law, when it comes to apply it, the court shows some hesitation. And it emerges from the judgment in Reich Montage, where the court stated that the rule applies also when some of the claims are inadmissible under the national law, even if in these cases it could be questionable if a real claim does exist. In fact, if a claim is inadmissible from its same outset under the national law, there is not a plurality of claims, and thus the requirement, the objective requirement of application of the rule is not really fulfilled. In other cases, the same relevance of the abusive misconducts is put into question, as it emerged from Freeport. But an approach which excludes the same relevance of the abuse could be questionable. And in fact, these arguments have been recently reconsidered in the cartel damage claims. In this judgment, the court, for the first time, finds a misconduct that, if proven, could lead to reveal a circumvention of the rule. And in that case, the defendants alleged that the claimant and the anchor defendant had reached an out-of-court settlement, but they purposefully delayed its formal conclusion in order to securing the jurisdiction of the court. And in such circumstances, the court finds that this conduct may be relevant to find an abuse, but for disapplying, in order to come to the disapplication of the rule, it is necessary that such misconduct is proven by the defendants. And in particular, the defendants have to prove that the claimant and the anchor defendant have artificially colluded to fulfill the application of the rule. For the court, such a kind of misconduct it's not proven in itself by the presence of a negotiation before the introduction of the proceedings. And thus it could be asked whether in presence of abusive misconduct it is possible to come to a lightened or reversed burden of proof, since it's very hard for the defendant to prove such a collusion if the burden of proof requires a firm evidence. And this burden of proof, in the cases in which there are alleged abusive misconduct, should be on the claimant, since it's for the claimant, it's easier for the claimant to prove the existence of a real claim if a real claim exists. To this extent, the existence of a real claim would be found where there is a real interest at the time where the claims are brought. And if this real interest does not exist, there is not a real claim, and thus there cannot be a connection between the claims. And thus, if there is not a plurality of claims, the objective requirement of the rule is not really fulfilled. In this perspective, the existence of a real claim could be an element which limits the scope of the rule. And the application of the rule, in this case, will be not applied if the choice of forum amounts to an abuse. Thank you.
Thank you, Lucilla, for this very stimulating, again, intervention. Again, we are far beyond the general principle of Article 4 of the Brussels one. And I'm not sure that the principle has to be overturned. You mentioned that. I'm not so sure, but for sure, there is a challenge toward actor sequitur. And it seems to me that the main challenge relies on the substantial approach, l'approche substantielle of international jurisdiction. And, well, I will be very happy to discuss this substantial or substantive approach substantielle of international jurisdiction, but the floor is yours first. Marta?
So thank you so much. Marta Requejo from the Max Planck Institute. I have a question for Etienne. Well, I have several questions, but I will start by just two, which are not logically ordered, so I will start illogically. Let's assume that we admit a forum actoris for torts, and to a large extent, the idea would be to protect a weaker party. So my first illogically placed question would be, why not for negative declarations, actions for a negative declaration? Because finally, if you want to protect the weaker party, it would be for the other party, so the non-weaker part, to claim for a negative declaration. So why not let it use a forum which is favorable to the weaker party? This would be the first question. But my problem is exactly this, that I do not see how you would define a weaker party. And your idea of transposing the doctrine or the making a parallelism with consumers, I cannot see it. In the case of a consumer, and the problem lies mainly with previsibility, in the case of a consumer contract, you have the contract which creates the previsibility in relation both to the parties to the future litigation and to the cause of action to the future litigation. In the case of a tort, even if you say a professional, this previsibility element is missing. And you could, of course, say the professional should know. He should know, so it's for him to assess the risks, and he's the one who could imagine and prevent that the tort is caused. Well, this will only work in some cases. And second, and I think this is more important, in this way of thinking, you are introducing into the equation a diligence element, which probably the element of which diligence should the professional have had in order to be attracted to the forum actoris. And this entails that you would have to have the applicable law involved already at the level of jurisdiction. Yeah, I can imagine that you don't agree. So to my mind, this idea of weaker party is really complicated to work out, and it will only work if you have a specific framework, like for instance you have in data protection, where you have the global framework starting with the idea that only natural persons are protected. So, well, I wait for your answer. Thank you.
Thank you so much. For the first question, I think I haven't made myself clear on that point, and I'm happy that you give me the opportunity to go back to that. Actually, in the case that you pointed out, where it's the alleged tortfeasor acting for actions for negative declaration, then why not just leave the alleged tortfeasor to sue the alleged victim at his or her home? It's a case of actor sequitur. It's a case of forum rei.
Yeah,
No?
so the idea would be that the tortfeasor sues or claims the negative declaration at the place of the domicile or the residence of the victim.
Yeah.
Yeah, this is exactly what I mean.
I think we agree that that would be best. So the reason why I say that forum victimae should not be open for a negative declaration is that it should not there should not be a forum actoris for the alleged tortfeasor. That's what I meant. As to your second question, of course, there are issues with sort of transplanting the regime for the jurisdictional protection of consumers in the realm of tort litigation. As to the question of predictability, of foreseeability, first, I would say that I'm always a little bit skeptical of when predictability or foreseeability is thrown in the debate, because I think we understand predictability to mean different things, and one of them could be that the tortfeasor is or not able to predict or to have a sort of clear mind as to where his or her activities are and where he or she might be in a position to create a damage, a loss to third parties. I think one element of answer is that indeed, in my mind, I think there's a fair case to be made that in many cases, the alleged tortfeasor is sort of in a position to foresee where his or her activity might have consequences. Then, in the other cases, it's also a matter of policy to decide that, it was maybe not in that particular case foreseeable, but nonetheless, the alleged tortfeasor will be sued at the victim's domicile. And I think the argument of comparing a contractual setting where there is a so-called previsibility or predictability or foreseeability, it also might be switched around, because there is, the question of predictability comes into play because it's a contractual setting, because the parties to the contract have had the opportunity to create predictions about what was going to happen. Whereas in tort cases, it might not be that relevant to place such a big emphasis on foreseeability, again, with the idea that it's not always clear what we mean by foreseeability or predictability.
Just a short answer. When you go to the applicable law, you immediately, in tort cases, you have the idea of the applicable law would be this or that. If regarding, for instance, product liability, in case the tortfeasor could predict that this was the law to be applied. So I would say that the predictability still plays a role, which is maybe, but this would have been another question of mine. How do you relate your proposal to the applicable law? So I think this is something you should also consider.
Well, I would also like to comment a little bit. You started, Etienne, by the general principle actor sequitur forum rei. It looks like a very bold principle if one looks at Article 4. But it is flawed by the reference to Article 62 and 63. If you look at those provisions, you can already see that when it comes to corporate defendants, you have a multitude of possible general fora. And when it comes to natural defendants, then you have the reference to the different national laws. So as a first sight, it looks very well balanced as an overarching principle. But I think the regime is not as clear as one would have expected in this respect. And I recall that Paul Oberhammer once said, why do we have acto sequitur forum rei? For very practical reasons. You have to summon the defendant. And in the former good old times, the idea having the bailiff close to the court and sending the bailiff directly to the domicile of the defendant made sense. And cross-border elements in the service constellations were already excluded. So from that perspective, acto sequitur forum rei is maybe not so overarching as one might expect. Also, I do agree, the Court of Justice in its case law went in that direction. I also have a little bit the problem when it comes, but no, let me put it another way around. It's always difficult to challenge a system, and it's always easy to defend it. Now I defend it a little bit in saying, well, how would you really define this idea of the victim, which to my impression comes a little bit from private international law. Of course, we had min potestas sas as a first case, which really, the circumstances of this case led to the result reached. It was a very easy, clear-cut situation in min potas, and then it became much more complicated. Yeah, and in private international law, this idea, sympathy with the victim in tort proceedings, that the victim may choose the applicable law, is an old idea which was a little bit transposed maybe to the Brussels Convention. And I have also one additional remark to the second presentation. And here I was wondering, Article 8, of course, is number one, is a very difficult provision, and the case law of the court demonstrates that the court is very cautious in progressing. But there is, of course, a link to the free movement of judgments, so to the second part of the Brussels instrument, and to avoid irreconcilable judgments. And I think this is an idea which is very important for the interpretation of 8 number 1. And when it comes to abuse, let me just give one example at CDC. I was in CDC on the plaintiff side, and I will never forget the moment we had a phone conference. And the plaintiffs said, well, we settled with the anchor defendant. And I said, oh, no, this is not true. When did you settle? That even before service was made to all other defendants. Was this really necessary? You are killing your case. And it was not killed. They found some good arguments. They had to argue a lot to overcome this abuse situation. On the other hand, if you come up with ideas of abuse, and they were, of course, in CDC, in the courtroom, these are, again, very difficult criteria to be proven. And this is maybe also the procedural circumstances we are in when we are at the very beginning of the proceedings. To what extent, it was in both presentations, should we really go for taking of evidence at this early stage of the proceedings? The court has not found a clear line there, neither.
Would you like to make comments or reply?
No.
No?
Thank you.
Okay.
No, but I totally agree as to what you said, so I'm...
Tobias Lutzi, University of Oxford. I, for one, almost entirely agree with what Etienne said, and a lot of that will actually come back in my talk on internet cases, which also relates to many of these problems. But I have one question. Why would you use this victims forum you're proposing also to completely replace the general ground for jurisdiction in Article 4? If I understood you correctly, you said that, but your argument is based on the problem of localization, and you're saying that it has implicitly been replaced by some policy concerns that are actually more concerned about protecting the victim than properly localizing a tort, which sometimes is just not really possible. But I don't see how that even affects the general possibility to rely on actus sequitur and sue the defendant at their domicile. And even in consumer contract cases, we allow the consumer to sue the professional at their domicile if they so wish. So I think this would create a lot of friction if you went that far. But for everything else, I fully agree.
Yeah, I agree with what you said. It's a question that I ask, should we go that far? The reason why I ask the question is that I think the claimant, the alleged victim, will only take advantage of the Forum Rei if they find another advantage to it, because otherwise they would sue at home. And I'm trying to find a balance, and but I would be perfectly open to the suggestion that a Forum Rei should remain open because it's a legitimate base of jurisdiction. However, I think we should be aware that it will never be used in favor of the defendant, which is fine. We can live with that.
Thank you.
Good morning, Wolfgang Hau, University of Munich. I'm sorry that I got you wrong the same way. So I think abolishing the defendant's domicile is really no option at all. When it comes to enforcement, you have the right to sue somebody where he has all his property, full stop. And I think, but I would follow you in many respects on the rest of your arguments, but I think it could be achieved much easier just by doing two things. First, agreeing that we should overrule Foley and Fischer, and we should get actions for negative declarations out of the scope of Article 7, number 2. Second, would be just to ask for a higher standard of proof as regards the alleged tort on the jurisdictional level. And then we would pretty much achieve the same results you have in mind with less complications. That's my suggestion. Thank you very much.
Yeah, I mean, I agree. I just don't see how high making the threshold for factual elements at the jurisdictional stage would make it easier for the claimant to sue at home.
Actually, now we have no standard of proof at all. We just believe the claimant that the alleged tort has happened, full stop, on the jurisdictional level. And that's very tricky for the defendant, because even if he's completely innocent, he has to go to the other forum and defend his case. That's not right. So we should have some reasonable standard of proof. That would be sufficient.
Is there any question? Maybe I come back to the substantial approach. Could you both tell us a little bit more about the influence of substantive law and the substantive approach to international jurisdiction?
Well, I think that in assessing the existence of an abuse, we have to take into consideration a substantial approach. I don't know if in the meaning you have in mind, but the abuse is always something that relates with a kind of infringement of substantial or procedural law. And I think that giving relevance to the abuse is necessary when, as in this case, we sue a defendant which is in another jurisdiction, which has a general rule on which he can count on. And so if there are abusive misconduct that we have to define, there is the need of a deeper consideration of the burden of proof, which is for me the core issue, because who has to prove what? This is the real question for me.
Yeah, so this is the taking into account of the substantial law, and your position is slightly different, I think.
Yeah, the question of substantive elements at the jurisdictional stage is always complicated because first, private international law tries to remain as remote as possible from the substance, and second, the procedural law tries to remain as remote as possible from substantive aspects. However, both private international law and procedural law very much deal with the substance. The case that I made here is that the way I see the substantive elements coming into play at the jurisdictional stage is those incentives that I mentioned, incentives to overturn actor sequitur forum rei. I think actor sequitur forum rei is very much based on a procedural credo, a procedural belief that, as I mentioned, the jurisdictional protection of the defendant. And I think this credo, this belief, is sort of being put away, removed by incentive at the substantive level without particularly paying attention to what law will be applicable. It's something that's, I would say, more deeply rooted within what is tort litigation. And of course, I know that what I'm saying now is really open to debate according to different jurisdictions. And but I think it's the explanation that I found most convincing if I have to give an explanation as to why we are straying away from actor sequitur forum rei.
Okay, I like this idea of actor sequitur like a procedural credo, because I think this is really important in practice, and you mentioned the service to the defendant and to all the issue of enforcement. But beyond, you have also the idea of presumption d'innocence, even if we are in civil commercial matters. So to overturn I'm sure that overturn is not the good way of thinking, because to overturn the rule will change also our substantial approach to law and the infringement of law. So that's why I will be a little bit cautious.
Yeah, I understand. However, in a way, it's already overturned, since there is always, in tort litigation, there's always the possibility for the claimant not to sue at the defendant's home. So, like, it's interesting to have this belief that the defendant is entitled to jurisdictional protection, but actually, that's not what we do.
Yeah, but this is part of being a credo, because there is the procedural credo, and then you have the practice and several substantial or policy consideration, but the credo still remains, and that's why this is a credo, I guess. The credo gives IDs.
Thank you, Björn Laukemann. I have a question for Etienne. I'm wondering whether you would see the risk that the procedural assessment in tort litigation is rather more based on the specific field of law that is underlying the litigation, the concrete case, and the specific legal environment. In the end, we are talking about IP rights and the specificities of IP rights. We're talking about IP rights in the specific legal environment of internet. We are talking about personality rights. We're talking about financial instruments in Colassa. So would you say that there is a danger of fragmentation in the sense that we, in the end, even if the court does not follow explicitly that way, that we are focusing on the underlying legal area and determine procedural law in the context of that specific legal environment? And would your approach to look at the weaker party be a counter-instrument to avoid such a fragmentation?
Yeah, it's a very interesting question. While I was researching for my PhD, one thing that struck me is this fragmentation. The fact that if we start to look at specific fields, we might have solutions that are specific to these fields, to this field. And at some point, I sort of toyed with the idea that maybe the proposal that I could make was to allow this fragmentation to happen. Let's have a forum victimae, say in IP rights, in infringement of personal rights on the internet, something specific for each field. This is not what I presented here, and this is not what I defended in my PhD. Maybe because I was more drawn to the idea that a general solution would be better, and that this fragmentation was something that was maybe not dangerous, but at least not something to be encouraged. Maybe because I'm also, I think, sort of seduced by the idea of a general theory rather than specific solutions. But definitely that's something that's there. And of course, you're right. Those specific solutions would be the product of the applicable law, or at least the specific law of that field.
Sabine Hackspiel, I would like to come back to what Professor Menétrey said about the credo of actor sequitur forum rei. I think maybe sometimes it has just been considered a bit too absolute. And I think what it's really about in jurisdictional questions is jurisdictional fairness. And probably the principle was considered that actor sequitur forum rei in principle is fair to everyone. But of course, it is not fair in every case. So I think what rather happened is that rather than overturning it completely, it is being limited or attenuated in the sense that it cannot be the overriding consideration all the time, and has to be limited in some cases when procedural fairness requires it. Of course, then there is the other question, procedural rules need to be simple also, otherwise they wouldn't be workable. And that's, of course, the big advantage of actor sequitur forum rei. But I think it's just a question of having it as a principle, and everything else must be a narrowly construed exception. And I think that's an aspect of the court's case law that I've always been a bit uneasy with, to say this is the principle and everything else has to be constructed narrowly. But I mean, the principle in itself, I think, needs not to be overturned. It just has to be framed correctly.
Yeah, thank you. Yeah, I totally agree with that. And this is the meaning of the Brussels I regulation itself. There is the core principle, the general principle, and then a set of exceptions. And that's why, I mean, it can be a credo because this is a really common principle, but credo has not to be understood in a very spiritual or absolute way. I totally agree with that, yeah. But if I may, I think about Marcel Sturm right now. And, well, I'm not sure that he will love the idea of credo or something like that, but he had an idea I'm really interested in, just to turn all civil procedure up and down and to say, well, there is no need of rule of standing because there is a presumption of breach of the law. So everything has to be on the shoulders of the defendant and not of the claimants. So, of course, I'm not sure of this idea, but that's why I think that our discussion is interesting in terms of thinking beyond some general principles. That's all, the credo and beyond the credo, of course.
Jens Kleinschmidt, University of Trier. I would also like to ask a question concerning Article 7, the jurisdiction in delictual matters. In the very beginning of your talk, you mentioned procedural reasons which underlie this special head of jurisdiction, proximity of proof and fact, and so on. And these considerations led to problems which you showed with case law of the ECJ. But I was wondering if, in the end, there are still procedural considerations for your proposal, because I saw a kind of a shift that was also discussed with the substantive approach to base your suggestion mainly on substantive elements of tort law and of tort liability. And I was wondering whether, apart from the problems that you see with the current procedural considerations for this case law, there are actually also procedural considerations that would speak in favor, genuine procedural considerations that would speak in favor of your solution. We talked about enforcement problems, service, and so on, that would actually pull the claimant to the defendant's domicile. And maybe a second question, if you're particularly looking at the weaker party, we have a jurisdiction in consumer contracts. Have you thought about extending this jurisdiction with a kind of annex jurisdiction so that at least in where we actually have a consumer contract, also tort claims could be brought in the forum of Article 17 and 18? Thank you.
Thank you. As to the first question, one thing that at least plays in favor of forum actoris or forum victimae, or in any case does not play in disfavor of this forum, is that both the evidentiary issue aspect and the enforcement aspects have been made, I think, considerably easier by the European regulations on, Brussels I regulation for one thing, and the regulation on evidentiary gathering within the European Union. And also, I think, and that is said from the perspective of France, French procedural law, we used to think that there was a clear prohibition against evidence gathering abroad, judicial gathering abroad, and I think this prohibition does not really stand. So I think there are at least enabling factors to a forum actoris of the victim, which is to say that those practical, very procedural elements that played in favor of actor sequitur forum maybe are weaker now than ever. The second question, sorry, was? Oh yeah, that's it's not something that I thought about, and I think it's a great idea. Again, that would require a consumer contract to be there, which is often the case. Like in Colassa, for instance, there was to some extent a consumer contract maybe, and it's just that the claim was not directed at the other counterpart. So that's something maybe to think about. Maybe the definition of a contractual claim should be really broadened as far as consumer contracts are concerned, and maybe it's the way. Maybe the recent case law of the Court of Justice will allow it. For instance, if we think of the Zurich case, I think, which sort of changes a bit the definition of the contractual claim.
Thank you very much. One more question. Yeah.
Yeah, just a very short question. This idea of a foreign actor is for the victim. Would you keep it within the system, meaning the Brussels I regulation, this regulation still requires the defendant to be domiciled at a member state? So would you still keep it in there, or would you make it broader for all kinds of cases?
Again, very interesting question. It might be made broader. Along the lines of what happens with the consumer contracts. However, I also think that when the Brussels I regulation is not applicable, usually domestic law, domestic and private international law, has ways of allowing the local plaintiff to sue at home. It's very clear in under French law, and I think in many other jurisdictions it's the case as well. So I think the pressure in favor of allowing the plaintiff to sue at home might find sort of channels that allow it to be expressed that don't need to take place in within the Brussels system, but it's always an option, yeah.
Well, maybe one additional remark. Here I would not agree with you, because what is the second overarching or the main principle or main idea of the Brussels regime? It's a free movement of judgment. And the moment you have a third state defendant in many, many cases, you cannot easily enforce a judgment you obtain within the judicial area. And I think this is something to be considered. This is why the defendant has to be domiciled in the union in order to have the possibility of easily enforcing the title throughout the union. Third states still are different.
I think we deserve a coffee break. And on behalf of everyone here, I would like to thank you both again for your very interesting presentations.